Thank you so much for joining me, Ricky. I really appreciate that. We've had a ton of questions from our clients, and generally, with the market the way it is, the biggest question that I get right now is, "Hey, I've sold my house. What if my buyer isn't able to complete that sale?" It's a very scary position to be in, and a sale is not closed until the keys are transferred at the end of the day, right? So there are instances. I mean, we've all heard about this where you've sold your house, you bought a new house, and come closing date or a few days before the closing date, you get a call saying, "Hey, we're sorry, we're not able to complete this purchase," and nobody wants to be in that position, Ricky. But from a legal standpoint, what are my what are my options? What can I do if I'm in that particular situation?
Amir, I think it's unfortunate, but I feel like, at least in my experience as a lawyer, when most people have an issue, it's on the day of closing. But the reality is that they've known that there's going to be an issue for weeks, if not months, before the closing. Okay. And so my number one piece of advice for most people is that if you're a buyer and you know that there's a good chance you're not going to be able to see the transaction through, don't wait till the day of closing. Talk to, whether it's through the lawyer, preferably through the lawyer, talk through your lawyer, engage the seller's lawyer and see if there's options. You never know. Maybe the seller has had seller's remorse, or they say, "You know what, we'll release you from the transaction because we thought we were going to find our dream upgrade home and we couldn't find it. And so we'd love to keep this home." It's something that happens from time to time, but it doesn't happen if you leave it to the last minute, where the seller's literally packed and has purchased a home that they didn't really want. And now they're really upset because they've sold a home that they shouldn't have sold or they didn't want to sell. So I think communication is important. Now let's assume that we get to the day of closing and the seller's lawyer is advised that the buyer's not in funds. Assuming that the seller's side is ready, able, and willing to close, then naturally the buyers are going to be found in default of that transaction. Okay. If a buyer is found in default of that transaction, the buyers theoretically got their money sitting in a real estate brokerage's trust account, and they're going to push for a mutual release. Now, a mutual release is a very special document. When you sign a contract, you're creating legal relations and obligations, rights and obligations in the contract. When you sign a mutual release, you're basically absolving that. Okay. And so one of the things that, if you're on the selling side especially, you may not want to sign, you should not sign factually, is a mutual release. Because if the buyer defaults and your intention is to pursue them after the default, by signing the mutual release, you've given up your right to sue. Okay. In which case you're probably suing your realtor or your lawyer for bad advice in that situation. Okay. Now, assuming no mutual release is signed, as a seller, what I'm going to do is I'm going to go ahead and mitigate loss. What this means is I'm going to act reasonably. I'm going to relist the property, try to sell it again. And after making reasonable efforts to sell it for as much as possible, theoretically higher than what you purchased it for from me, if I end up suffering a loss as a result of that subsequent disposition, then theoretically I can sue you for the difference. Now, it's easier to say than it is to do in most instances, because litigation is sometimes like a game of chicken. Some sellers don't have the capacity to pursue it all the way. Some buyers don't have the capacity to pursue it all the way. So it becomes a question of, what's the actual loss? Is it worth pursuing? If it's less than $35,000, for example, small claims court is pretty straightforward. A seller can start the process of getting the real estate trust account to release the deposit that's held in trust. But if you don't have a mutual release, you need a direction or a court order in that instance. Okay. So you've got to start navigating these things very quickly. But more often than not, what will happen is if the seller can't sell it, then they're going to sue the buyer for the difference.
Interesting. Okay. So let me just back up here for a second. So let's say I'm the seller and the buyer is not able to close the transaction. So right off the bat, what happens with the deposit, Ricky?
Deposit's stuck unless it's released. Now, let me give you a couple more scenarios here. Okay. So first scenario might be that, the buyer, they normally don't say that we're not going to close. They're normally going to push for an extension because the mortgage agent is trying to whip up a miracle. Okay. If I'm acting on the seller's side and the buyer's lawyer is asking for a extension request, I'm going to ask for a couple of things. So first thing I'm going to ask for is I'm going to ensure that the statement of adjustments remains as of the original date of closing, meaning that my seller, they agreed that that was the sale date. They're not going to pay any property taxes, any maintenance fees, anything that would be adjusted on the statement of adjustments after that date. So the buyers are agreeing to be responsible for that. The second thing I'm going to look for is a further deposit. Now, if you're buying $1 million property and most properties in the GTA are over $1 million, you need at least 20% down. So if I've got a 5% deposit sitting in the real estate trust account at the brokerage, I might be pushing to up it to 10 or 15% if I can get it, because I know that theoretically that buyer is going to need 20%. And if they don't have it to give to me at that time, they probably don't have it. Yeah. Right. And so again, it goes back to that game of chicken, like how far do you push and what's reasonable? Now, after I've got the second deposit, the third thing I'm going to push for, if I can, is to have an irrevocable direction executed by both the sellers as well as the buyers that directs the listing brokerage to release the deposit to the seller in full if the subsequent closing is not completed. Meaning that we're going to give you the extension, you're giving us a deposit, statement of adjustments remains as of the date of completion, but that deposit that's sitting with XYZ brokerage in their real estate trust account, if you don't close on that second date, all of that money is released to the seller. Now, by doing this, I ensure that my clients aren't running around trying to get a court order for someone to release that money. It's done beforehand. Okay. So those are the three key things I'll typically look out for. Now, a lot of people think that, lawyers are there, killing deals and what have you. We actually try to salvage deals when possible. Okay. And again, with time, with notice, if we're given ample time to be creative, a buyer might say, hey, my appraised value came out $180,000 less than I agreed to purchase your home, and I can't close it because I don't have the difference. There might be options like a vendor take back or a seller take back, where the seller actually gives a loan, but it's going to depend. And this is where good mortgage agent advice comes in, because you want to make sure you've got adequate equity and down payment in the property, because if property values decline further, then the seller is never going to see that money either. Okay. Now, I've seen instances where the buyer says, my appraised value is $180,000 lower. Why don't you reduce the price by $180,000? We'll close the deal. And then the seller will say, no, we're not going to do that. They'll go and mitigate loss, and then they'll sell it for $300,000 less. And that's interesting, right? Because as a buyer, if you're suing me now, I'm going to say, well, I offered you $150,000 more than you sold it for originally when we tried to negotiate this. So it becomes very interesting how we navigate this territory, right?
And I think every situation is going to be different, right? In the example that you just gave, yeah, they could have potentially taken the $150,000 loss and closed, or they could have opted for a VTB, a vendor take back, where they could have then held a second position in that house that they were selling for $150,000, which was at least payable at the time of sale or within a year, 2 years, whatever it was that the contract was made up on. But if they didn't do that and they ended up selling the property for, let's say, $350,000 less, like you said, now how would the seller go after the clients, after the buyers for the difference?
Yeah, they would have to litigate the matter. Yeah, so normally, they'll start, and I think most people will try to settle beforehand, right? And so if they can't settle their affairs beforehand, then the next natural step is to hire a litigation lawyer, prepare your file, and then litigate the matter. And, if it's more than 35,000, it's not small claims court, so you've got to go to the right court. You need the right type of litigation lawyer to litigate the matter and take it that direction.
So generally, how long does that take, Ricky?
It can take a long time. And that's the thing, because as a buyer, you're now in limbo, right? Mm-hmm. If, especially post-pandemic, with some of the backlog we're seeing, if it's going to take 2 or 3 years for someone to get to your file, like I'm reading cases now from 2018, 4 years later, right? And so it puts you in a precarious situation as a purchaser, because you don't know what's going to happen until it happens, right? And I think that's why a lot of people, especially in times like this, they look for creative options, whether it's B side or even C side. I've had clients who say, I'm going to close this privately, because my mortgage agent's going to work on something and then we're going to refinance the property 3 or 4 months down the road. We can carry it for a year. It's all about coming up with those options in a situation like that. Breaching the agreement for most people doesn't make sense. Again, sometimes it is a game of chicken. Buyer might realize that seller doesn't have the financial wherewithal to pursue it. Litigation is very costly. So they might say, I'll take my chances and see what happens, right? Some buyers might say, hey, I'll release my money to you without you doing anything, whatever deposits there, but in exchange, I want a mutual release. So now some sellers might say, you know what, I'm not going to spend the next couple of years in court. I'm going to walk away with $40,000 or $50,000 clean now, and I'm going to deal with it. We've seen all kinds of things happen in this.
So I think the misconception that I've noticed mostly in the market is about deposits being liquidated damages. So a lot of people seem to think that you would have access to the deposit right away if a transaction does not close on time, right, or it fails to go through. So that is not accurate.
So let's talk about deposits for a second. A buyer's deposit is the amount of money that they're agreeing to prepay, like the base amount that they're agreeing to forfeit in the event that they've defaulted on the transaction, like right up front. Okay. Now there are situations where if the deposit is an egregious amount, that a court will say that's too much. It can't be liquidated damages. But theoretically, that's what it is. Okay, it is liquidated. It's the base amount that you've agreed to part with if you don't close the transaction. Okay. Now, some buyers think, oh, if I sign an agreement and I don't bring my deposit, I can just walk away from the deal. It doesn't work like that. Okay. Because the deposit doesn't bind the contract. And so we end up as lawyers in situations where buyer says, I changed my mind, after a multiple offer presentation situation, and they think that by not putting the deposit, they're in the clear. When the factual reality is that if I'm advising the seller, we're going to send out a letter 1 minute after the deposit's late, putting them on notice that they're late, they're in breach of contract, and we're going to mitigate and resell the property to a third party now. And any sort of loss that we suffer as a result of them not bringing that deposit and seeing the transaction through, we will be pursuing as well. I think, again, what ends up happening is sometimes you've got an agent or you've got a lawyer that isn't versed enough where they'll say, oh, we can't accept another deal until we sign a mutual release. That's not true. We've seen lawyers and brokers get sued for bad advice. And so it's really important that you have the entire file reviewed by someone, and then you get sound legal advice before you proceed one way or another. You can't just walk away by not putting down your deposit.
Got it. So clearly, this is a mess on both sides, right? And it is in everybody's best interest to close the transaction as originally agreed upon, right?
Yeah, whenever possible. Again, like between the real estate broker, the agent, the mortgage agent, the lawyers, you want to work together. We've seen situations where one appraisal comes out lower, and then we requisition a second appraisal and it comes out a lot higher. Yeah. But again, these things take time. And if you leave it to last minute, then you end up with real trouble. That's when these problems occur. If I would know, for example, a month before closing, usually it's a 60 to 90-day closing for average transaction. And so if I know as a seller's lawyer or as a buyer's lawyer that my buyers are not going to be able to close, I might be able to communicate with the seller's lawyer and say, hey, we're looking to assign the transaction. We want, permission to put the property on MLS to sell it to somebody else because we may not be able to sell it. Okay. We're going to look for potential solutions so that if we really can't close on the day of completion, we can at least show that we made sincere efforts to try to reconcile the matter. It doesn't look so great when it's the day of closing and you throw your hands up and now the seller can't close their purchase and that purchase can't close their purchase, and it's this huge domino impact.
Well, you exacerbated the losses for the seller as well at that point, right? Potentially. But I think you're absolutely right. If anybody is in a predicament like that, make sure you reach out to obviously your solicitor, your mortgage broker, and work with these professionals to figure options out for you. Don't go by hearsay, because there's a lot of miscommunication. People seem to think that litigation is like this. It can, within 30 days we'll have our money, and it's not that simple.
Yeah, it gets really crazy. And you know, it's not just the simple purchase and sale. Sometimes, like I said, with the domino, you know, the purchase that the sellers have tried to complete, they can't complete. And this buyer might not have any option, right? So we see a lot of interesting things happen. And again, without communication, without the timing, like it's very challenging to navigate these things, especially, you know, everybody's trying to close at the end of the month. Everybody's trying to close on the last Friday of every month.
It's always,
And
always
and
the
that's
case.
something I always advise against. Close on a day where everyone's free to just work on your file. Don't leave it to the last Friday of the month. Don't leave it to the last Friday before a long weekend,
Yeah,
right? Because
amazing.
you want to make sure that whoever's working on it is going to be able to work on it, especially in a situation.
Well, hopefully anybody's watching this, they won't have to deal with this anytime soon. But you know, thank you so much, Ricky, for giving your you know, your advice. And yeah, if anybody has any questions, please feel free to reach out to me or Ricky. And you know, thank you for watching. Thanks, Ricky.
Thanks, guys. We'll see everybody later. Bye for now.
Take care.